we're going to go on the record in Bonneville County Case 24-0849, State of Idaho versus Gerald L. Hamlin. Mr. Hamlin is present along with counsel Mr. John Thomas. The State of Idaho is present, represented by Mr. Randy Neal. And once again, I apologize, I forgot your name.
Yes, Your Honor. Stephen Hatterley for the state.
Mr. Hatterley, also representing the State of Idaho. We're here today for a scheduled sentencing. We're ready to proceed in this matter, Mr. Thomas.
Yes, Your Honor.
Stay ready, Mr. Neal.
Yes, Your Honor.
Mr. Hamlin, let me review the history of this case. At the time of your arraignment on February 20th, 2023, you're informed that an information had been filed against you by the State of Idaho, charging you with count 1 as an indictment, which was murder in the first degree, 2, accessory after the fact, willfully withholding or concealing knowledge, and 3, destruction of evidence. You pled not guilty at that time. However, is there a problem?
She heard the court's recitation. I think she made a mistake of what originally happened, and so she said the word guilty. She thought that there was, I think she's referring to the latter plea, but I'm not sure who said it, but I think that was what they were trying to say from the gallery.
So not have any comments from the gallery. You pled not guilty at that time. However, on July 23rd, 2024, you again appeared in court with your attorney pursuant to a plea agreement, pled guilty as charged to counts 2 and 3. The plea agreement that was submitted to the court was that the state agreed to recommend that the defendant be sentenced to a retained jurisdiction. The parties were free to argue the underlying portion of the sentence. The defendant also agrees and represents that he will continue to provide truthful information to the state and the court concerning the circumstances related to this case and the co-defendants, specifically but not limited to Randy Larkin. Further, the defendant represents that he has not withheld any material information related to this case currently known to him, and the agreement of the parties was based upon those representations. The defendant also agreed to pay restitution, all charged and uncharged crimes. Everything else was free to argue. Included in there was that count 1, the first degree murder charge, was to be dismissed. This plea agreement was non-binding as to the court. After I accepted the guilty plea in this matter, I ordered a pre-sentence investigation report be prepared. I have received that report and reviewed it. A copy has also been provided to counsel. Let me ask Mr. Hamlin, have you had a chance to review that pre-sentence investigation report?
Yes.
Mr. Thomas, are there any parts of that report that need to be clarified or corrected?
No, Your Honor.
Mr. Hamlin, do you wish to stand by the plea of guilty you previously entered in this case?
Yes.
There are going to be witnesses on behalf of the defendant.
No, Your Honor.
Any witnesses or victim impact statement on behalf of the state?
Yes, Your Honor. Would you like to do those now?
Yep.
Okay, Judge.
We're going to start with Jennifer Kramer, who's the victim's mother.
Ms. Kramer, if you want to come up, we can either pull up another chair. Chair, I'm sorry, you're on crutches. Whatever is most comfortable, you can sit or stand. How are we doing this? Is this a written one that's going to be read, or?
Yes, Your Honor, she's written a statement and she's going to read it.
All right, Ms. Kramer, before you start reading it, if you could just say your name for the record and spell your last name.
Jennifer Kramer, K-R-A-M-E-R.
And then I think we're picking you up fine, so you don't need to worry about the microphone. Just speak as you normally would. I will caution you that people read faster than they normally speak.
Okay.
So if you could work on not reading too quickly.
Okay.
Okay, thank you.
To the Honorable Judge Pickett, I am Morey's mother. I'm writing this impact letter to express the profound impact that the loss of my only child, Morey,
Do we have some tissues over there? Remember, take your time. I don't want to rush you. I mean, like I said, we've got all afternoon. Take your time if you need.
Your Honor, she's asked for me to read it for her.
That's fine. May I do so?
You would like me to start over?
Yes. And just for the record, it's Ms. Millhouse, victim witness coordinator for the prosecutor's office. Go ahead.
Your Honor, just so the record is clear, we can probably excuse the reporter from recording this, word for word, because what the court's already referred to about reading it kind of faster, and then we would submit it for the court reporter so she can include that in the record if that's the court's preference.
I'm going to have her recorded. Go ahead, Ms. Millhouse.
To the Honorable Judge Pickett, I am Morey's mother. I am writing this impact letter to express the profound impact that the loss of my only child, Morey, has had on me. The pain and devastation of his murder and the involvement of Gerald Hamlin and his accomplice are beyond words. The moment I received the news of my son's tragic death, my world shattered into a million irreparable pieces. The knowledge that he was left alone to die while his perpetrators callously drove away fills me with a grief so deep that I struggle to find words to describe it. The void left by his absence is a constant reminder of a future stolen, dreams shattered, and Morey's 2 boys left without a father. The recent developments in the case, specifically the reduction of charges against Gerald Hamlin, have only added to my anguish. I strongly believe that justice must be served in its entirety for the heinous crime committed against my son. Gerald Hamlin played a role in this senseless act, and he must be held accountable for his actions without any reduction in the charges. The pain of losing my only child has changed me irrevocably. Every day is a battle to navigate through the overwhelming grief and emptiness that now defines my existence. The thought of Gerald Hamlin facing a lighter sentence for his involvement in this tragedy is a burden too heavy to bear. I implore the court to consider the full extent of the devastation caused by the actions of Gerald Hamlin and to ensure that justice is served for my beloved son, Morey. The void left by his absence can never be filled, but knowing that those responsible are held accountable would bring some semblance of peace to my shattered heart. Gerald Hamlin has helped to create a wound that will never heal. He sits there with his minimal understanding of the destruction he caused and my only son's life he helped end. I hope he carries the weight of this knowledge with him every day of his miserable existence. May every night he close his eyes. When he closes his eyes, he be haunted by the echoes of that gunfire that killed my son. He is forever a part of his murder, and I hope he understands that his soul is forever stained by this act of violence. Shame on him. He will never be free of this. Enjoy the reality. Sincerely, Morey's mom, Jennifer Kramer.
Thank you very much. Then we'll have you return to your seat. Other witnesses or victim testimony?
Yes, Your Honor, and this is from Jennifer Spalding, and she's asked that Ms. Millhouse read this one into the record.
Go ahead, Ms. Millhouse.
Your Honor, my name is Jennifer Spalding. Is Morey Pelton and I's son. This is coming from my perspective as a mother, and this is our story. I will never forget the day that I found out Morey was murdered. My dad and I sat down and told together that his dad was taken out of this world, and I watched as my 12-year-old boy cried in agonizing pain. It was one of the worst moments of my life. This has caused me so much grief, trauma, and anxiety. After finding out this happened, I had to go back to school, and everyone knew what happened because it was all over the news, and that has caused a lot of mental and emotional issues. We had so many people that reached out and were worried about our safety after hearing about the traumatic death of Morey. My family and I spent months before anyone was arrested in Morey's case, worrying if we were going to be put in danger next. Gerald needs to be held accountable for his actions and the part he played in Morey's death. We will eventually find forgiveness in our hearts for the part he played in this murder, not because Gerald deserves it, but because we deserve to have peace, and holding on to hate and anger will only hurt us in the end. I feel he would be a threat to society, and I want to see positive change and to be able to feel safe now to have to raise my son alone. He is constantly asking me questions about his dad, like what he would do or say in certain situations, and Morey is not here to give advice or help with the knowledge that Morey has learned in the 36 years of his life. As a 14-year-old teenager, it can be extremely confusing and difficult at this age in trying to discover who you are as a person, and as a single parent, it can be hard to do it on your own without the other parent involved. He is not going to have his dad for any big life events in the future. He is starting high school this fall, and his dad will never get to see him graduate high school. He will never get to see him go on his first prom. He will never be there for his wedding, and he will not be here when he has children of his own. We have done positive change, and by doing that, in counseling once a week and dealing with his dad's death in his own time. I am also in counseling for how to deal with Morey's death and receiving the help I need to help my son get through this tragic death. Because I've been in counseling, I know it is our responsibility for our own healing process, and knowing Gerald would be held accountable for his actions would help with that process. This is a lifelong process of working through the trauma and intense grief of the violent act for both. Not only has this had an impact on myself, but the people that love both and I, and everyone who loved Morey. Morey had a love for the outdoors and the mountains. We like to take fishing and up in the mountains. There's a type of healing and comfort that makes us feel close to his dad. There's been so many tears shed, and the immense pain we feel has been unbearable at times. This will forever be part of our story, and we are survivors of Morey's murder. Thank you, Your Honor, for taking the time to hear the impact that Morey's death has had on our family. Sincerely, Jennifer Spalding.
Thank you very much.
Okay, I'm Morey Pelton,
Want to spell both those names?
Martinbelton.
Go ahead, sir.
Okay, well, my son's dead. Every day I wake up, I'll try. Every day I wake up, wishing I could talk to my son. Just one more time, wishing Morey was here in my empty house. Our plans to go fishing and hunting are over. Morey was my only child, the only new family I had left. My pride, my breath, my joy, my world. Morey was my everything. Morey was a good man with a huge heart who had the whole life ahead of him. Morey was a kind person, would give the shirt off his back to anyone. Morey was my friend to call, was a friend to call if you needed help. Morey had left 2 children. His life was ended abruptly, without reason, without explanation. This has almost been the death of me. I hang, the glasses on might help. I hang on for my son, missing him greatly every minute. Morey cannot speak for his grief. Morey deserves justice. I visit Morey's memorial site almost daily. This is where he took his last breath. I ask myself, why did this happen? The pain I feel is unimaginable. Why did Mr. Hamlin or anyone call 911 or the police? Why didn't Mr. Hamlin or anyone try to render help to Morey? Or call me and let me know my son's at a restaurant bleeding to death in the rain? Mr. Hamlin did not tell the truth to the police. Mr. Hamlin hid evidence, destroyed evidence, and left the state for 18 months. There are still unanswered questions. Mr. Hamlin is truly evil, showing no remorse. To my knowledge, a RIRIE program is where drug offenders go to be taught a lesson. A slap on the hand is not definitely what is needed here. Prison where murders and accomplices go If he's lucky enough, death row. A writer program is 6 months to a year. I will spend the rest of my life, day and night, thinking about these actions. They should have to spend the rest of their lives thinking about the consequences to their actions from a jail cell for planning and executing the murder of my son, Morey Pelton. I won't speak for Morey's children. They have also been deeply affected. These two boys will never know their father since they were so young when his life was taken from Mr. Hamlin. No hunting, no fishing, no experiences that boys should be able to share with their father ever. Not to mention my life, and what it consists of now every day without him. Counseling, therapists, struggling every day at work, at home, mentally, socially, and emotionally, and struggling every day to live life or go on without him. Your Honor, I ask you to put yourself in my shoes, put yourself in Morey's shoes, put yourself in before you make any decision to sentence this man.
Thank you very much. Hold on, Mr. Moore.
Mr. Pelton?
We need a copy of that report.
Yeah.
If Mr. Pelton's statement was in writing, the court reporter would like a copy of that just to make sure we get it all for the record.
Martin. Your Honor, Mr. Pelton also wanted to submit, looks like 8 photographs of him and his son.
Mr. Thomas, see these?
The ones that I received, Your Honor, were in black and white, but this is basically what I saw prior to, just in color.
Any objection?
No.
I'm going to mark these and have them attached to the recent investigation report. The court received them as well. Got black and white pictures. Let me take a minute now. Anything else, Mr. Chairman?
No, Your Honor, just argument.
Mr. Thomas, before I announce sentence in this matter, I'll give you this chance to speak on behalf of your client.
Thank you, Your Honor. Your Honor, this is a tough job for me when I have a client who was involved in something like this. But I understand the profound grief that the family feels. And I understand and I can see, and it came across that these wounds are still very much open and very raw. And that affects me. That hurts me to know that someone's life has been altered because of things that happened. But at the same time, we have to look at what he was actually convicted of, what he's actually pled guilty to, that being withholding or concealing knowledge of a felony from a peace officer. So, over and above everything else, Mr. Hamlin needs the court to understand and to take into consideration the fact that he withheld evidence, withheld knowledge of the fact that he was there when someone died. But he wasn't an active participant in what happened, and he's not being convicted of that or judged for that. That is for another day, for another man. Gerald Hamlin has no respect, no love, no care for Randy Larkin. He will testify against Randy Larkin. He's indicated that. That is part of the plea agreement. And he wants the family to know that there is no love lost between he and Randy, that he was not a victim in this case, but that he was pushed in unwillingly into this situation. I know that the mom talked, and she said that, you know, Gerald has a minimal understanding of his actions and the profound grief and the profound impact that what happened on that particular night has had on the family and on his friends. And Gerald knows that. But unfortunately, due to consult with his attorneys, we've said, don't say anything. We're not going to say anything. We're going to let everything come out in court at the time of Randy Larkin's trial. And so while it's heavy on Mr. Hamlin's heart that he has to sit here and see the family in such grief, in such pain, in such agony that they've lost a loved one, he doesn't want them to think that he's not here to help them in some way. He's here to help smooth things over, make things right. And I know things are never going to go back to where they were when Mr. Pelton was alive. And Mr. Hamlin knows that. We've talked on a number of occasions about that. We'd like the court to know that the PSI and the state are both recommending a retained jurisdiction. We feel as though that's an appropriate outcome, as the PSI writer indicated, based on the severity of the offense and the fact that someone died, that's an appropriate outcome. The destruction of evidence, Mr. Hamlin did destroy some evidence in a roundabout way with regards to this case. The evidence that he destroyed, and this will come out in the Larkin trial for the family, but the evidence that he destroyed had to do with the drugs that he was bringing down for Randy. It had nothing to do with the murder or with the killing or anything like that. It had to do with, I'm going to take these messages out about Randy asking me to bring drugs down. That's what the destruction was about. And so I know that Mr. Pelton asked you to put yourself in his shoes, and that is what Gerald and I have been trying to do for the last several months as we've been talking about this case, as we've been working through it. You know, Gerald just wants the court to know that he is extremely remorseful for what had happened. It's not a situation that someone normally gets into where they're in the midst of something like this and then they go on with their life and are approached by police, and there were so many unknowns of, well, gee, the police are approaching me, what should I say? Should I, you know, I'm afraid for my life because Randy Larkin is still around. You know, these are the things that were going through his mind. These are the things that Gerald and I talked about. You know, he said, I was afraid for my life. I'm afraid for my parents' life, is what he said. Randy Larkin had that far of a reach in his mind, that he could do bad things to him or kill him. Or the way it came out was that Randy Larkin had said to Gerald, people that are snitches end up in ditches. And so that was the signal that Gerald got, like, hey, I need to keep my mouth shut. Did he do wrong? Yes. Should he have said something immediately? Yes. Should he have gone to the police and said, hey, this happened and this guy was the one and I drove him there and on accident? Yeah, there were thinking errors. Absolutely. And for that, Gerald should go on a rider and learn, do the Thinking for Change program. That's a great program that they have. That's a great program to learn from. But are we going to get anything out of this where Gerald is going to put himself in this kind of a position again? Never. Gerald and I have talked about this, and he said, I'm never giving anybody a ride. I'm never going to put myself in a position where I put my family at risk or somebody else's family at risk. People that I don't even know. We just talked about that today. I know that there is no closure and that this sentencing hearing for the family is not going to resolve that and is not going to give them the closure that they want. At the end of the day, accessory willfully withholding, concealing knowledge of a felony from a peace officer holds a 5-year, $50,000 maximum penalty, and the destruction of evidence, alteration, or concealment likely also holds a 5-year but a $10,000 possible maximum fine. So we would ask the court to see this raw, open wound for what it is, and to look at Mr. Hamlin, look at his background, look at his prior history, and understand that he was there. He did what he did, and he is paying for that. He spent almost 10 months in jail already. He's had a lot of time to think about the pain that his ancillary action of driving Randy Larkin to this particular spot and allowing Randy to get out of this vehicle and do what he did and then drive off. He's had time and time again to think about that, and to think about, man, all the lives that I've changed based on my stupid action of leaving and not telling anybody. So what I'm asking the court to do is to go along with the plea agreement and to go along with the recommendation of the PSI writer and put him on a rider, retain jurisdiction. I think 1 year fixed and 4 years indeterminate to give the court some time to be able to keep him on probation for a length of time would be appropriate. And I would ask the court to run these cases concurrent. I don't think that there is a consecutive need here. I don't think that what he did, based on all the facts and all the circumstances, and as the court reviewed the PSI, the law enforcement's version goes on for several pages, and I certainly don't want to disparage Mr. Pelton or the things that came out in that report, but this is not just a cut and dry, Mr. Hamlin drove somebody to some place knowing that he was going to kill him, had this person killed, drove away knowing that that was the result, and then moved on with his life. That's not how it was. It's far more complicated, and the court knows that. So I believe that a 1 year fixed, 4 years indeterminate with a retained jurisdiction is appropriate. I think that time may not heal all wounds in this case. This case devastated a family and a community, and my client doesn't plan on coming back here when he cuts out. He plans on moving back to Washington, moving on with his life as much as he can. So that would be our recommendation, Your Honor. Thank you.
Thank you, Mr. Thomas. Mr. Neal, kind of states your recommendation.
Thank you, Judge. We are here as a result of a plea agreement, which is based largely on, as the plea agreement clearly lays out, the full cooperation, the full honest and candid explanation of all that Mr. Hamlin knows about this particular event. And I do agree that based on that plea agreement, it's certainly important for the state to make clear the boundaries of our recommendation, which is that we do believe that with that kind of cooperation, that with the 10 months of incarceration and the additional retained jurisdiction and the truthful and full cooperation in the prosecution of Randy Larkin, that Mr. Hamlin it would be appropriate for Mr. Hamlin's plea agreement recommendations to be followed. The disagreement where I think counsel and I will focus on today is mostly on what are going to be the underlying sentence. Where is the underlying sentence going to land? if we do not see either full compliance with probation or that there's in any way further criminal activity by Mr. Hamlin, because he's made a lot of promises to the court in his PSI. Counsel has represented a lot of assurances to the court, but this is not a case where someone got caught up in some minor criminal activity. This isn't a case where a girlfriend hit her boyfriend when the cops came knocking at the door. This is a case of the most severe nature. This is a first-degree murder, and it just can't be lost on anyone that there should never have been a presumption that Morey Pelton couldn't have been saved if Mr. Hamlin had done what is expected of every citizen. And it's a legal obligation. It's not something that would have showed good character. It's not something that only good people do. It's a requirement of the law. And there's a reason for that, and that would be to minimize the impact of the crime that he was very familiar with. And he must have understood the grave nature of what happened. The shot that entered into Morey Pelton entered in near his neck and then lodged here in his chest. He fell out of that car onto the pavement. There were two other cars there, one with Kelly Hinks in it, one driven by Mr. Hamlin. They both fled the scene. And as Morey laid on that pavement at 10:30 at night, in the dark, in the rain, bleeding from that severe wound, no one was contacted. And he wasn't discovered until 8 o'clock the next morning. We cannot guess what difference in outcome there could have been but for a simple phone call. And I just don't think that there was no way for that call to be made. Despite the fear, despite the concern for himself or his family, that call could have, and by law, had to be made. Because Morey Pelton was dying. When that occurred, we'll never know. But his best chance at survival was an obligation of everyone who knew about it. And that's number one. That's case count number one for which Mr. Hamlin has pled guilty. I just don't know how that particular crime could get more severe. That obligation is for every felony. But in a case like this, when there should have been knowledge that a person was injured by gunfire, and that best case scenario, some kind of help could have prevented his death. But even in the worst case scenario, it still was a legal obligation. Mr. Hamlin did not call. He did not call after he left the state. He did not call after he returned to Washington. And one of the reasons I think that it's helpful to the court to see the description of this case, which goes from page 1 to page 10 of the pre-sentence investigation, is to understand just how difficult it was to solve this case. There were months of delay because no one came forward with the truth, even under circumstances where it could have been reasonably understood that protection could have been there and that this case could have been brought to justice. evidence which was lost could have been potentially recovered. The investigation was severely hampered because this was a true whodunit. They didn't know who was involved. And it wasn't Mr. Hamlin who came forward, it was Mr. Hamlin who was tracked down. That's when information, essential information in this case, was first uncovered. So the idea that we can reduce the severity of the conduct here is hard to square with the facts. So the most that we can see come out of this case, and that is established by law. But when we look at this case and we say, even with the full cooperation of Mr. Hamlin, what is necessary, what has to happen in order for us to have a just result for the conduct that occurred, 5 years is not enough. So in our putting this plea agreement together, we kept 2 counts. These 2 counts, as counsel has already acknowledged, really talk about 2 distinct crimes. Two distinct crimes that occurred at different times. One was the basic conspiracy to bring methamphetamine into Swan Valley to give and deliver to Mr. Larkin. Mr. Hamlin, as he saw that the police were getting close and would know the details about that particular part of this incident, which is actually 2 distinct occurrences, then made the decision, I'm going to destroy evidence to keep myself out of trouble. Not because he was threatened, not because he worried about his family, because he worried about himself. So this is absolutely a crime where, when we combine both of these factors, that 5 years is not appropriate, and a 10-year sentence, in other words, a consecutive sentence, is. Not only does that allow for more probation time, which is appropriate, there should be a lengthy probation time so that all of the promises and statements and assertions here can be proven. And then we can ensure that any further conduct will result in an appropriate punishment. For that reason, I am requesting that the court have as an underlying sentence on both cases a 2.5 fixed, 2.5 indeterminate, but that should be consecutive. Now, if Mr. Hamlin follows through on his promises and his assertions here, and even this coincides with the LSI, then he shouldn't have much to worry about. But the court needs the tool, and the court should expect that Mr. Hamlin is going to comply thoroughly with the law to the fullest extent allowable, and in this case, that's 10 years. So here's the things that that are concerning in the pre-sentence investigation. In about 2000, Mr. Hamlin was convicted of drug trafficking. He was given a significant amount of opportunity to address that with the potential for the drug, the addiction that he had. And he was successful on that, and then he was able to address that and receive some rehabilitative relief as to that conviction.
Your Honor, before we go any further, I'd like to make an objection. It was not a drug trafficking charge. It was a manufacturing, delivery, possession with intent charge.
Page 15 of the PSI, criminal history.
Hold on. Go ahead. So, Mr. Neal, let me get to it. I have it on page 19, but that's...
Page 15, under criminal history, convicted of drug trafficking in about 2000.
That would be inconsistent with the actual prior record that they got from NCIC, Judge, so.
Page 19, this is a violation of the Controlled Substances Act of Washington. Manufacture, deliver, possess with intent, both charge number 2, for which he received an imposition of sentence, and charge number 4, for which he had an imposition of sentence. So those 2 convictions are found in both page 19, and I believe referred to then on page 15.
Hold on. So, Mr. Neal, the court, Mr. Thomas is correct. The charge of manufacturing, delivering, and possessing, not trafficking. Those, I recognize that's a term. These are term of arts that the court uses, but it wasn't a trafficking charge. It was the manufacture, deliver, possess. But the intent is still there, which was manufacturing or delivering drugs.
Very well, Judge. We're relying upon what's before the court right now on page 15. But, his longest period.
I want to be clear. The court's going to rely upon the NCIC record, which is the official charge.
Okay.
So you're free to argue whether it's traffic. I'm just saying whether it's trafficking or delivery. It's him giving drugs to somebody else.
Very well.
Trafficking weight or distribution weight, that's irrelevant to the court. It's him providing drugs.
I see. I'm not sure that they have the same kind of based on weight trafficking law in Washington. So maybe that's the difference. But I think we're on the same page. And yet, so that was in the year 2000. There was a rehabilitative relief. Now, what starts this is a similar behavior. Now, it was Mr. Hamlin wasn't caught with the drug, but in page 16, he says he admits to committing both crimes. And the second crime had to do with deleting evidence that had to do with bringing the methamphetamine to Swan Valley. Now, whether,
Can I
go ahead.
interrupt for a second? You said 16, I don't see that on page 16.
Attitudes and orientation, displayed a moderate criminal value system during pre-sentence interview. Admits committing both crimes, semicolon.
I got that, but I didn't see the description that you're.
Right, I think he's.
Hold on, Mr. Thomas. So is it referred to somewhere else? I mean, you're telling me that's what the evidence is, but I don't see that referred to in the report.
Page 16 is the report.
I understand that, but you said he admitted to both crimes, and then you're talking about him delivering methamphetamine to Swan Valley. I don't see that on that page.
Both crimes refer to the crimes that he's pled guilty of. The second crime was the destruction of evidence related to the conspiracy to bring methamphetamine to Swan Valley.
Your Honor, I think the court's acknowledging his embellishments on and on the ambiguities that are in page 16, and so we're good if the court is good.
Go ahead, Mr.
The extents of these are already pretty clear, I think, in the court's mind. There's no embellishment necessary. I mean, this is the severest nature. So, yeah, that crime needs to be punished likewise because of the nature of the effect that it has on the ability of the law enforcement to do their job. So, is there a great deal of consideration going on here based on cooperation? There is. But that's not to say that there is no significant or severe underlying offenses here that the court is putting forth a sentence for. And that's the reason I think that our recommendation that we start with this retained jurisdiction. We do work on this criminal thinking and associations and all of this nature of what Mr. Hamlin describes led to this kind of situation. Ultimately, we have to look at, well, what if he doesn't? Talk's cheap. Well, if he does, then he has nothing to fear. If he doesn't, the tool needs to be in this court's possession to make sure that there's a significant consequence. And so that's why we make the recommendation we do. I think ultimately, it's probably difficult for us as legal practitioners to ever fully ingrain the reality of what was happening. We see photos, we see them often. We see very tragic, we see very violent situations. In this particular case, the autopsy report, the nature of the crime, all of these things are going to be, somewhat antiseptic evidence. But the nature of what we're dealing with, it really boils down to what the court is seeing. These folks are the victims of these crimes. We have a mother, we have a father, we have children. Nothing that we can do will bring a father back into their lives, or a son. And yes, Randy Larkin pulled the trigger, but Gerald Hamlin gave him the getaway. He was able to leave that scene and avoid detection because of the assistance he got from Gerald Hamlin. So this wave of destruction that's going through this family, through these loved ones, through that community, we'll never know how much of that could have been prevented by following through with the obligation of the law that we all have, not just people who get along with the cops, not just people who have an easy opportunity to make a phone call. The obligation was here in a humanity way to try to save this man's life, and it didn't happen. That's not just being, not just a matter of bad character. That's a matter of not following through with the legal obligation, which is supposed to minimize the very effects that we're seeing here today. I mean, we just can't overstate those. So for that reason, these are acts of the most severe nature that are described by or proscribed by these two statutes. And for that reason, the most appropriate penalty is to make sure that this court has those tools necessary to ensure that Mr. Hamlin follows through with the promises made to this court.
Let me ask you a question before you sit down. Has to do with the plea agreement and has to do with his agreement to testify in the case against Mr. Larkin. That's currently scheduled for November.
Correct.
The issue is that if I follow the plea agreement and send him on a retained jurisdiction, and then we bring him back to testify, that then create issues for that program, potentially causing him to not be successful in that program. Any thoughts on how you wish the court to handle that, the transport, the process?
Sure.
So for example, he comes here, if he's in a writer program and then comes here for a month, he's either going to have to restart it or be terminated from it, and so I guess I just wanted your thoughts on that.
It's not our intent to have him return for a month. But I think really, so there's two parts of the plea agreement that clearly outline the cooperation that he's intended to follow through on. Page 4 or 5, there's a pretty lengthy paragraph 8 that talks about the nature of how he is to cooperate and provide those truthful statements in the upcoming trial. There's two possibilities. if he wants to take the chance of going on a retained jurisdiction before November 14th, 15th, which is about a little over a month away, then he runs the risk that the rider program will say that we got to restart, you're missing too much time. If he wants to start as soon as possible, which may be 4 weeks anyway, but if he wants to start and take that risk, then of course we'll minimize as much as we can the impact on the program. It's not our intent to make him start over or to fail the rider program. And we can minimize the amount of time that is essential for his testimony, which may be a day or two. That will depend on defense counsel and the way they approach this witness. But I don't anticipate we're going to bring him back and have him sit in the county jail for a month. Absent, that's what he'd rather do, so he doesn't end up extending his time in the retained jurisdiction. So that would be the approach I would suggest.
And let me indicate I haven't fully decided yet what I'm going to do. I just, as I look forward, I see those potential issues. Mr. Thomas, any thoughts on that before I turn it back to Mr. Hamlin?
Yes, Your Honor. My client would ask that the court make a phone call or do whatever it has to do to get my client out of here post haste so that he can begin the program. I know that we have made an affidavit as to what Mr. Hamlin's testimony will be at trial, that the state is satisfied with that testimony. There's not going to be lengthy preparations. It's a 6-hour drive probably, or maybe a little bit longer from here to Boise to the prison to get him over here and back. I've been through several month-long trial, and I understand that you don't call everybody over there for the entire 2 months, and so I think that the state's approach of letting him get up there and get his rider started, if the court is willing to put him on a rider, which I believe is the appropriate manner here. But if the court is willing to do that, then we would ask the court to get him out of here as soon as possible so that he can start the program. And if they need to call him back, he may miss 1-2 days max. So that's what I would ask for.
Mr. Heim, before I announce sentence in this matter, I'll give you the chance to address the court. You are not required to say anything, nor do I hold it against you in any way if you choose not to. However, if you do wish to exercise your right of allocution, I would give you that chance. And if you are going to address the court, if you could please stand. Or anything you'd like to say? Okay. Are you satisfied with the representation of your attorney? Is that a yes? Thank you. Mr. Thomas, is there any legal reason why I should not sentence the defendant today?
No, Your Honor.
Mr. Hamlin, based upon your pleas of guilty, it is judgment of this court that you are guilty of the crime of count 2, accessory, willfully withholding, concealing knowledge of a felony from a peace officer, a judge, or jury, or count 3, evidence, destruction, alteration, or concealment. I've carefully reviewed the record in this matter. As indicated, I've read through the reports, the pre-sentence investigation reports, the judge over this case as well as the Larkin case, so I'm familiar with the allegations. I have listened to the argument of defense counsel, listened to the argument of the state, carefully listened to the victim impact statements that were both read by the victims as well as the victim witness coordinator. The court has the obligation of reviewing this sentence in light of the objectives of criminal sentencing adopted by the Idaho Supreme Court, that of protection of society, deterrence of this individual and the public generally, the possibility of rehabilitation, and punishment or retribution for wrongdoing. It's always difficult when I read those objectives on a case like this. And I've noted many times that there's nothing in there about the victim. And the victim impact statements were given were powerful. I took notes, even though I'd read through some of those, and note that some were similar to ones the court had already reviewed. But when Ms. Kramer, I just wrote those comments that I thought were very powerful in expressing not the loss and the pain. When Ms. Kramer wrote that Mr. Hamlin, or that Gerald Hamlin left Mr. Pelton alone to die, and that description of that. There was a discussion of the reduction of charges, Ms. Kramer. I understand, like I said, the court is not aware of evidence that would show that Mr. Hamlin had any foreknowledge or pre-knowledge, which would change the circumstances. I know there was an investigation to that. And so, frankly, the charge that Mr. Hamlin has pled guilty to is probably, as far as this court's aware, and as I understand the state's aware, is what the charges are. That there was no foreknowledge of or premeditation as to the murder. And so I understand Ms. Kramer's concern about the reduction in charges. However, the state, who has investigated these, has a lot of experience dealing with these types of cases, has agreed to dismiss that charge. However, there was another statement Ms. Kramer made that I thought was powerful. This is a void that can never be filled. And that's true. There is, sadly, and I've sat on this bench for 10 years as a judge, and sat for 10 years as a prosecutor. There are crimes that happen where a void will never be filled. And I thought that what Ms. Kramer said was very appropriate and very accurate. Ms. Spaulding said a couple things, that no one will know the loss of the son and the parents, and that this will be a lifelong process of grieving. And that's true. Mr. Thomas himself says that, you know, they say the time will heal all wounds, but that's not true. I agree that that's not. There will never be a time that this loss will be gone. Now, will people deal with it? Yes. Will people learn to live with it? Yes. And I want to tell the victim's family that is possible, that you learn to live with it, but that doesn't mean that it goes away and that loss isn't felt, because it is. And sadly, as an attorney and as a judge, there is nothing that I can do. There's nothing that can be done. There's nothing that society can do to bring back Mr. Pelton. When Mr. Pelton talked about the things that he would do with his son, and he asked these questions: why did this happen? And why didn't they render aid? Those are completely legitimate questions that should be asked, and that the state is attempting to answer with these charges. The prosecutor is limited to what the legislature has determined, what the charges are, what the law is, and what the penalties are. In this, Mr. Hamlin has pled guilty to accessory after the fact, which the legislature has determined is a 5-year penalty, which is someone who has knowledge of the crime and withholds it, which Mr. Hamlin did. He acknowledged that loss. He acknowledged he did it. And then count 3, the evidence destruction. Once again, the legislature determined that's a 5-year sentence, possible penalty for the destruction of evidence. Once again, that's what Mr. Hamlin did. I think the evidence is clear that Mr. Hamlin was there, he drove the car. I'm not aware, and I don't believe the state is aware of any direct evidence that would show that Mr. Hamlin had any foreknowledge of the murder, but he did afterwards, and he should have done something. And as a society, I agree with the state that that's an obligation that we as a society expect. Whether it's, in this case, I mean, what Mr. Neal argued is we'll never know. I agree, we don't know. Was there immediate loss of life? I don't know. Did he lay there in the dark? I don't know. And we won't. And that's one reason why society expects people to act in situations like this. You can't just hide and say, oh, I wish that wouldn't have happened, or I hope I don't get caught. And throughout my career, I have held that belief that when someone dies people have the obligation to act. And if not, that they are prosecuted. And that's what society expects, and Mr. Neal has done that in this case. But Mr. Thomas's point is made as well, that we are only here to sentence Mr. Hamlin for what he has pled guilty to, accessory after the fact and evidence destruction. I also don't fault Mr. Hamlin for agreeing to testify. I think that's appropriate in this case. And I understand, I've read through the reports and know what Mr. Thomas is talking about when Mr. Hamlin felt like he'd been threatened as well and not knowing what to do. Now, the fact that this went on for as long as it did, and as Mr. Neal argued, and I thought powerfully so, that Mr. Hamlin had to be tracked down. He didn't make the phone call and say, okay, I realize my mistake, this is what I know. And at some point, maybe not that night, even though that's probably what we would hope would have happened, but at some point, Mr. Hamlin had the obligation to contact law enforcement and say, this is what I know and this is what happened. As indicated, I appreciate the victim impact statements. However, I think the Supreme Court has acknowledged that there's nothing the court can do that's going to lessen the loss or bring back Mr. Pelton. And I often wondered how or why we can do some of those things, but we can't. So this court's obligation is to sentence Mr. Hamlin for those crimes which he has pled guilty to. A review of the crime talks about on page 2 that Mr. Hamlin was interviewed by the detective, and it's interesting because in the report this is a very quick 2-line thing. I think there was an interview, he denied it, they moved on. Because it says, Detective Houston spoke with Gerald Hamlin, who denied knowing about Mr. Pelton's demise. And they just move on with the investigation. So that was very early on. Later on in the investigation, it's on page 6 of the pre-sentence investigation report, indicated, this is in September of 22, detectives interviewed Gerald Hamlin. He reported that his friend Doug gave him the silver Mercedes. Mr. Hamlin claimed he was in Idaho during May, who he considered a daughter, and he also met with Keegan Mon. Mr. Hamlin eventually acknowledged he drove Randy Larkin to the Lane Clark rest area on May 12th. He said, you know what happened? And yeah, I was there. Mr. Hamlin then gave other information. Mr. Hamlin then indicated he'd been acquainted with Randy Larkin for approximately 9 years and was closer friends with somebody else. So ultimately, in this case, Mr. Hamlin did begin to tell the truth. Should he have done it earlier? Yes. Should he have acted that night? Absolutely. Did he have the obligation to do so? Yes. And I think the destruction of this charge speaks for itself, that there was an intent to hide that evidence and to destroy those text messages. Going on with this crime, and it talks about really how little Mr. Hamlin knew the victim in this case, and frankly, I believe that Mr. Hamlin was involved in criminal activity, but did not know about the murder, and that's exactly what is being sentenced for today. However, sadly, that's not the end. There's another trial. We've already discussed that on the record. I've read through the victim impact statements, also the letters of support. I wanted to refer to the defendant's version of the crime. Where he said, and he did not say this, but he wrote this in the victim impact statement. Talks about how he's sorry he sorry how I feel. I wish things would have been different. Morey would still be alive. I can't believe one man's selfish choices could hurt so.
I apologize.
That's
It's
all right.
diabetic pain.
It's okay. I recognize you're hard of hearing. If you need to take a second, adjust it. Okay, I just want to have a clear record. You can take your time. Continuing on, it talks about how I want you to know that in my plea I will testify and hope that he gets what he deserves. And ultimately he says he's very sorry and about the loss. It's appropriate, but it does very little. Ultimately, in this case, as indicated, the court will do its duty and sentence the defendant for those crimes that have occurred. The court has considered in this matter the plea agreement. Mr. Hamlin has a prior criminal record that includes 3 prior charges in Washington, Iowa, and Idaho. In 2000, he was convicted, I'm referring to page 22 of the pre-sentence investigation report, convicted of drug manufacturing, served a period of incarceration prior to being placed on parole, denied any use of methamphetamine since his release from prison. However, due to association with individuals in Washington, he knew where he could obtain the drug. Does not currently meet criteria for substance abuse treatment or mental health treatment. Mr. Hamlin acknowledges wrongdoing in this case and expressed remorse for his part in this crime, reported being ready to face consequences for his actions, and is motivated to help bring justice to the victim. There is a plea agreement for retained jurisdiction in this matter, and this appears to be an appropriate sentence given the loss of life. That's from the pre-sentence investigator. So I have a recommendation from the defense of a retained jurisdiction. I have a recommendation from the state for a retained jurisdiction, and a recommendation from the pre-sentence investigator for retained jurisdiction. Based on all these factors and considering the criteria out of Code 1925-21 relative to the question of whether I should place the defendant on probation or confine him to prison, submit the judgment of this court, the defendant be sentenced to the custody of the Idaho Department of Corrections as follows. For a minimum term of, on count 2, a minimum term of 2 years, followed by an indeterminate term of 3 years for a total of 5 years. On count 3, for a minimum term of 1 year, followed by an indeterminate term of 4 years for a total of 5 years. It's going to be the order of this court that those sentences run consecutive. So it's the maximum sentence that the court can give, which is the 10-year sentence. I'm going to order a fine in this case on each count of $1,000. Standard court cost payments in the Victims Relief Fund. Mr. Neal, restitution, is that to be determined, or where are we at on that?
I think that motion was filed on the 8th of October for a total of $5,063.
That was yesterday. We didn't get a chance to look at that. We just asked the court to leave it open for 30 days, and we'll file an appropriate objection if we feel need to.
Okay, I was going to say I don't think I received that either yet, but oh, there it is. Let me take just a quick look. That's the crime victims compensation. The court will allow 30 days for the defense to object. If not, the court will order it at this point since it's been filed. I'm going to order reimbursement of the county for public defender service in this case to be paid to the state public defender in this matter in the amount of $1,000. Court at this time is going to retain jurisdiction. send defendant on a rider in this matter. I do that specifically with the intent. I contemplated ordering him to do that time in prison. However, the court wants to retain jurisdiction in this matter to allow the transport of the defendant back and forth easier. And if I retain jurisdiction, this court retains jurisdiction over the defendant in this matter. So I'll retain jurisdiction for up to 365 days. Send the defendant on a rider in this matter. How that works is this court does retain jurisdiction. I'll receive a report about a month before that program's done, depending upon how the defendant has done. The court will either place him on probation or have him do the remainder of his prison sentence and relinquish that jurisdiction. So the court's retained jurisdiction, so it has control over the case, while the other co-defendant, the Larkin matter, continues on trial. Give you credit for the time she's served up till now, and continuing forward, the time she's served and will serve. Let me advise you have the right to appeal. If you have a Supreme Court from this judgment conviction, you have a right to represent a binding attorney in that appeal. You cannot afford one. One will be appointed to your public expense. However, you only have 42 days from today's date to do that. You also may have a right to seek relief under the Idaho Uniform Post-Conviction Relief Act. Such an action must be filed within 1 year from the date the right to appeal expires. You also have the right to seek relief under Idaho Criminal Rule 35 if you feel this sentence was illegal or unduly harsh. The court's also going to order the collection of a DNA sample and a right thumbprint consistent with Idaho code. Mr. Neal, anything else on this matter at this time?
No, Your Honor.
Anything else, Mr. Thomas?
Just for clarification, Your Honor, the court sentenced him to 2 years fixed and 3 years indeterminate on count 2, and then I got 1 year fixed and I didn't get an indeterminate. 4?
1 plus 4.
4 years indeterminate.
So it's 3 to 10, whatever it means, since those were going to be consecutive.
Very good, Your Honor.
And anything else on this matter, Mr. Thomas?
No, Your Honor.
As you know, the court doesn't, I'll do what I can to look at the transition to the retained jurisdiction program, or that's up to the Department of Corrections to do that. Other than that, we will be in recess on this matter.
All rise.